I have the great pleasure and honor to be with Attorney Phillip Kruse in Zurich, Switzerland. Mr. Kruse, thank you very much for taking time to answer my questions. You have 25 years experience in your field. You filed criminal charges because you represent people who got damaged by the COVID vaccines. And you filed criminal charges. It was July last year. It's a 300-page document. Can you please tell us about this case?
Thank you very much for your invitation to this talk, Dr. Schustereder. It's a pleasure to be here. Yes, it is correct that I'm with my team together. I filed a criminal complaint against the Swiss Supreme Authority for the authorization of medicaments, of medical products with the name Swissmedic. Swissmedic is this authority. And the criminal
would be the FDA equivalent.
Which would be the equivalent to the FDA in the United States. This is correct. And in the same 300 pages document, which I filed primarily for 6 concerned people, 6 victims of these mRNA substances, we also filed criminal complaint against the doctors who applied these shots. So all this combined in this document, which we accompanied, by the way, with an evidence report where we put in and explained all the factual evidence that was available and was the basis for our criminal complaint, which also has 300 pages. All this is online visible. We have published it mid of November last year, 2022. www.complaint-coronacomplaint.ch. Yes.
Right.
So what did we do? We filed ultimately for these 6 concerned people criminal complaint against Swissmedic for not respecting the minimal requirements that are necessary for authorizing these special medical products, then also for not respecting the minimal standards when it comes to the information of the people, by disinforming the people about the true nature, quality, and the true risk factors of these products. And then thirdly, also for not carrying out a meaningful and an effective pharmacovigilance that would be necessary and also mandatory in these cases. So in these 3 areas, we have filed criminal charges against Swissmedic, against responsible people. I must be precise here, responsible within Swissmedic. The presumption of innocence prevails, of course.
Could you show in these 6 concerned people a clear causality between the injections and the health damages these people experience? And there has been one 20-year-old woman who even died.
Yes, this is correct. So these others who survived, these 5 concerned patients, there we could show a clear causal link between the mRNA injections and the damages they are suffering still today. Number 1, simply because there was a very narrow time window between the application of the mRNA shots and the appearance of all these kinds of damages, of symptoms. But also we have engaged a doctor, respectively the patients and our clients went to a doctor who carefully examined the entire patient's history, did some additional complementary testing, and ultimately provided a proper analysis, a Gutachten analysis about exactly this question. How can it be proven that there is a causal link between these injections and the side effects?
So there is a solid proof that there is a link between the injections and the damages. These criminal charges have been filed in July, so this is an ongoing case. So where is this exactly now? What can be expected? What are the next steps?
Yes, this is right. So as I said, we have these two types of criminal charges. The one type is against Swissmedic, the responsible people within this authority. There we are still waiting for the confirmation of the competent authority that they took the case on. Here we are still waiting. We are in correspondence with the authority that handles the distribution and handles, let's say, the procedure of establishing which authority is competent. And it's a bit technical, but we are still in this procedure, and we will increase our evidence, the factual evidence, but also our legal arguments to make it clear that it must been taken on and by which authority it must be taken on. And this is the Federal Prosecutor's Office who must take it on based on the criminal charges or the criminal complaint we make with respect to wrong information in documents from Swissmedic. Swissmedic, in our opinion, has provided misleading information in their documentaries or documents accompanying the medical products. But so this is where we stand here, and we are about to do a profound update of the entire evidence that has emerged since last summer till up to now, and will submit our updated version of the evidence report, which will come to about 150 additional pages now, maybe 200 additional pages, to show that all what we have said so far, that these substances have no positive effect, that they are not capable of producing immunity, neither active nor passive immunity, that they simply don't work, and that they are actually a highly risky substance, risking the health of the people to a higher degree than any other substance in history before. And so that we will produce within the next couple of weeks to increase pressure. But we have a positive development when it comes to the second type of procedure.
Just one question.
Yeah.
When you talked about misleading information about a medical product, is it precisely what you just explained, that they do not provide immunity as it has been promoted actually, and also as meanwhile admitted by Pfizer themselves that it does not prevent transmission?
Yes,
we have correspond to the misleading information part?
Absolutely. Swissmedic still today has on its homepage, on the Q&A, under the question, do you know of any severe side effects? And they simply say, no, we don't know anything about any severe side effects. This is brutally wrong. But there are several provisions, legal provisions, that we use for making here the case. One set of legal provisions can be found in the Swiss Code for Medical Products, Heilmittelgesetz, and then there is a provision in the Swiss Criminal Code, Article 317, Urkundenfälschung im Amt, which means a falsification of documents by an authority. And here we are talking about actually providing wrong information by the the accompanying documentation that is accompanying the products. Probably better the word, die Heilmittelinformationen, die dem Produkt beigelegt sind.
Yeah, the specific information concerning
Yes.
health product. Yeah.
Yes, the specific official information that is the result of an input from the producer, and then a review done by Swissmedic. And Swissmedic ultimately is the responsible authority for the content of this accompanying information. And so what we are missing there is many, very strong side effects that are not listed as side effects, but that have turned out to be reality due to the pharmacovigilance registers of FAERS, United States, and register in Europe, EMA, where we can clearly say that many strong side effects do not appear in the documentation.
Question, because we're still at the first
Type of
procedure, yes, of procedure,
Yeah.
Which is against the health authorities,
Yes.
in this case Swissmedic. Now Swissmedic could say, well, in fact, I mean, this is an experimental product. We have not the data yet available. We're still waiting for all the data. So the information provided so far is in fact not complete. And we have written actually in the documents made available for doctors that this is a limited authorization. Doesn't that protect them?
Well, if they had done so, no, actually, they haven't written that clearly enough to the doctors. Actually, they have hidden this fact that we are talking here about, and limited authorization, limited in scope, in time, but also limited in the depth of the examination itself. Swissmedic didn't have a clue about what they were about to approve. They didn't have one single proof of efficacy, and not one single proof of safety. And still, up to our days, this proof is missing. And this was possible.
So this was simply not available.
It was not available, but under the impression,
under
the impression of an emergency,
Right.
It was arguable. They argued that they had the reason to make it, to authorize and to make this product available to the market under the impression that this emergency was so severe. But in our criminal complaint, we show that this was absolutely not the case. We have very clear provisions that allow for such an authorization only for a population that is under specific threat because of a virus to actually lose their life or to become invalidized, to become severely ill permanently on a permanent basis.
Yeah.
So we're talking here about, in theory, maybe people 80 and above, in theory. But then again, in every single case, the doctor has, that's a different question, of course, make an evaluation whether in this specific case there is still a benefit or not. That's a different question. But the second procedure, the second type, is with respect to the doctors who were responsible for applying these injections. Or we must understand first that in Switzerland, every kind of treatment, invasive treatment, like injections, are considered a physical assault, which is a criminal charge in Switzerland, unless the doctor can provide consent, an informed consent, based on a written document and signed document. And the notion of informed consent has the widest possible sense in Switzerland. as well as in the United States, I guess, and certainly for sure I know in Germany and in Austria as well. And it can be best summarized by the sum of all the information that is necessary for the patient to understand all the implications for making a decision whether yes or no this substance is necessary, is beneficial to him, and ultimately whether there is harm associated or not. Risk beneficial risk-benefit balance. And so we are talking here about quite a bit of information. This is a new product. It is not much was known up to December 2020, other than it was a new technology. We have meanwhile a huge amount of information in the public registers of side effects, in particular with respect to severe side effects. And so all this information should have been produced to our clients ahead of their decision before getting injected with mRNA, and that was not the case. Our clients, in the consequence, got physical harm, and this is why we also incorporated in our big criminal complaint, our complaint against the doctors. Yeah.
So you made very clear these two different kind of cases. Let's stay now a little bit more and dig a little bit more into the second case where criminal files have been charged against the doctors who did inject these products. Now, when these products came for larger use here in Switzerland, I made a big effort to learn as much as possible, and I felt very uncomfortable from the very beginning because I didn't get the data and the information. And I'm also quite familiar with the ethical codex of our National Medical Association, and there very clearly there is written in Article 10 that doctors are obliged to provide information for the patient, not just regarding diagnostics, but also regarding treatment, and to do a conversation, or to have a conversation with the patient in a way that he understands all the information. So I'm obliged to communicate as good as possible with the patient. So when I saw the data is not out there, and it has been made very clear that this is still an experimental product, how can I talk about the long-term consequences when we don't have yet the data? So for me, it was obvious this is a very, very problematic situation, and doctors going to be in a very difficult place if they engage themselves in such a medical procedure. Now, let's take the situation of a general practitioner, and the general practitioner sees his patient, and let's say the patient is already is 40 years old. Let's take that case first. And we know from the epidemiological data, actually this is not a risk group, and let's say he has no comorbidities, he doesn't take any medication, he's in good health. There's no reason to inject an experimental product. The situation is very clear. Would you agree?
This is absolutely correct. And I mean, if you have asked me 5 years ago about this case, my question would be, why do you ask? It is so obvious.
Right.
Nobody would probably even take into consideration to recommend a substance where you have no data about efficacy and about the safety. And in particular, not for a group where you don't have any problem with COVID-19. And this is the case.
So this is a clear no-brainer. We got no benefits.
It is a no-brainer.
If you just take all the risks, you have no benefits.
Yes.
And yeah, maybe long-term health damages.
In addition, what we can say from the Swiss regulatory perspective of our legislator, in the first place, we must say that this substance should never have been authorized, in particular not for that age group, because we have in our law, it says clearly that an authorization can be granted only for the group that is under threat for life by these viruses, or under the risk of suffering, you say invalidity or invalidität. So who is under the risk of having a permanent severe illness through this virus.
Right.
And so that can clearly not be said for people in the age below 60, 70, looking at the figures of hospitalization of the year 2020, because the hospitals were, for all these age groups, less crowded than in Switzerland than in the years before 2020.
Right. Now let's take the case of a general practitioner who sits down with his 85-year-old patient, and yet, I mean, even in this case, if the doctor is a conscientious working medical professional, he must say, actually, yes, you're part of the risk group, but we just don't have the evidence that this is a safe product, and certainly we don't know what the long-term side effects are. So actually, I cannot give you any certainty about this product. So actually, if somebody is really honest and conscientious, he must say all this, give all this information. And then if the patient still says, I absolutely want to have it, even then, if the doctor decides to give him this injection, the patient must sign a paper. He needs a written consent that the patient absolutely wanted to have it, and he gave the information, what's known, what's not known. Is that correct?
Yes, absolutely, absolutely. And here again, I would make also a big question mark already with respect to the risk group. Because yes, we have seen a large number of people dying in this age with a positive PCR. What we haven't seen were autopsies. So nobody has to prove that it was indeed and truly COVID-19 that brought these people to death. And there's my big first question mark. If we start legal actions and measures that are imposed by the state, we better do so only after we have the proof. What is the reason for it? And here we don't have a proof that the reason for these high numbers of, relatively high numbers of dying people was COVID-19 primarily. We don't have this proof. But you're talking about two other qualities that every substance should have before it is injected, and that is efficacy and safety. And as by lack of any empirical data, even to the contrary, in view of the fact that more and more empirical data provided proven evidence that these substances were absolutely not effective, were anything else but safe. So that should be part of an informed consent conversation provided by the doctor. Yeah. And at least the minimum the doctor should have said, depending of course on the time, you could, in the beginning of January, you could not be based on any empirical data, then the doctor should have said to this patient, 85 years old, we simply don't have any data at all with respect to humans, no empirical data, whether it is short-term, medium-term, long-term, just nothing. Would you volunteer for a substance where nobody can provide you substantial proof for its efficacy, for its safety? Personally, that's your decision, but I have, as a doctor, the duty to inform you about this black box characteristics. It's a black box. Half a year later, already VAERS and EMA data showed the highest ratio of side effects, even of severe side effects associated and notified for these COVID-19 substances
since the existence of
these registers. So that, in my view, should be a red flag, or at least the doctor should say, look, I've never seen that before. I've never seen that before for any other product. Me as a doctor, I'm obliged to look into these registers for new products, and we are here in uncharted waters. What I can tell you is, it doesn't look good.
Right.
You know?
Right.
So, and what you are describing applies, or what I just said, applies also irrespective of the age of the patient.
Yes. Yes.
Right?
So
So,
the different levels.
in summary, no matter what the age is, number one, we don't have the proof that COVID-19 was the real reason for certain difficult periods in the hospitals, difficult periods with people dying. We don't have the proofs because simply the necessary investigations and autopsies were not done. And number two, with more and more time, we have the proof that there's a lack of efficacy and there's an extreme high degree of risks associated with this product. So it's a no-go, and this is why we do our criminal complaint to have repealed the authorization of this COVID-19.
From the discussion we had so far, it's very obvious that for reasons of self-protection, nobody should give these injections in their clinic. That's a very, very people, the doctors, or I would be in a very uncomfortable position giving these injections with all the uncertainty and lack of information. But things have actually been, in reality, a bit different because most of the people who got these injections, they got it in vaccination centers. And there actually, a lot of the people who injected weren't doctors, weren't even not nurses, were sometimes people who did do their civil service, for instance, have even been not medical professionals, have been trained for a couple of hours how to disinfect the skin, how to pull out the right dosage into the syringe and then injected it. So these have even been not medical professionals doing the injections. It's in the vaccination centers.
Yes, absolutely.
Who is responsible in that case? In case of severe damage or slight damage after the injections?
Responsible is actually the organization or those people who are responsible for these vaccination centers. These vaccination centers are machineries to have people injected without any informed consent. If you do that in a large-scale basis, this is a professional fraud, and this is a professional physical assault. With potential leading to the death or to premature death of those who are vaccinated. Clearly, responsibility is with those who put these vaccination centers in place. So we have a chain of command of people who here is in charge, who is criminally liable. Going up from the head of these centers, then in Switzerland, it's either a hospital and or directly a canton, Swiss canton, and then probably we would find in the chain of command somewhere our Federal Office of Health, Bundesamt für Gesundheit, who has probably provided a very strong advice, set up these vaccination centers.
So I ask you this question for a very simple reason, that those who feel less well since they got the injections, there is a way to take action, and there are procedures that can be defined to identify who has been responsible in the context they have been involved. That's basically what you're saying.
Yes, absolutely. Absolutely. We're talking here about compensation, right for compensation of physical damage, of mental damage, Genugtuung,
Right.
well, the right of being compensated for having suffered a non-physical harm, right? And it is important to understand for those who are concerned that it is first the doctor and those who acted to these centers who are taken into who must be pursued before there is this famous claim against the state in general based on our legislation of the Epidemiengesetz. We have a provision which protects people seemingly, in case of a severe damage resulting from vaccination. Yes, we have so in our code of epidemics, but this applies only after a people has tried every reasonable effort to get compensation from the involved people, the doctors, respectively those who are responsible for setting up these vaccination centers. That's important to know. And yeah.
Right. So let's come back for a moment to those colleagues who refused to participate in injecting these products, because there has been pressure, severe pressure from the medical authorities here in Switzerland on the doctors who did not recommend the injections. And it was very clear, all the people who are part of the risk group, you have to recommend these injections. You don't do it, you're in trouble. That's basically what happened. And we got letters. People have lost the license to practice, and there has been a lot of intimidation, and dialogue has been extremely complicated. So what is the legal base of a medical authority to say you have to recommend this?
None. Actually, the opposite is true. An authority has to refrain from putting and pushing people into these situations, because the highest law we have in this context is enshrined in something we refer to as the Nuremberg Codex, but we also have it in written law into one of these United Nations conventions for political and civil rights, this Article 7, which clearly said it is absolutely forbidden to bring people into an experiment-style situation without a free, informed consent, which we have here. And this provision, Article 7, of this International Agreement of Political and Civil Rights, even applies in situations of emergencies. So authorities cannot say here, oh, look, we have COVID-19, we have the public health emergency of international concern, we don't have the time to consider, to go into the details, just do it. No. So the opposite is true. There is a clear prohibition for doing so. Then you have on the national level also the law you mentioned, the provision Article 10 of the law for Swiss medical doctors, FMH, you know probably better.
Codex, right.
The Codex, yes, right. And then also you have the Swiss Federal Court practice that clearly says without, as I mentioned already, an informed consent based on all relevant facts and proven by a written signature, such a treatment is considered to be a physical assault, right, resulting in criminal charges. Right. So what I want to say is that these authorities have to refrain from exercising pressure, have to refrain from doing so. They should say, look, we have a new product here, we don't know anything about it, you are the experts, you do your own assessment, but make sure one thing, that the patient has a full basis of information of all the relevant facts.
You're aware that things have been even worse. I have colleagues, didn't happen to me, but I have colleagues, and we talked a lot about it, where the police showed up. Police went right into the clinic, closed down the clinics, and so this went even further.
The police showed up. Why did they show up?
Police showed up because they have been involved by the medical authorities. Computers have been taken away. For instance, people who did do certificates for not wearing masks, for instance, who were putting specific information about what we are talking about, the lack of data regarding the injections, or to put into perspective the whole pandemic from, let's say, epidemiological point of view. That's rather an issue for the elderlies, etc., etc. So I know these colleagues, and yeah, even the police has been involved.
Yes, I have heard of these cases. I was just asking what type of reason did they use of justification, what kind of justification. Yes, this is, I must say, the opposite of what our government should be doing to protect people. And it will be part of a larger process of reassessment, of reconsideration. And the first step from my perspective that I was able to contribute was the criminal complaint against Swissmedic. There we have the first step of making all these authority actions possible, and that's the authorization. We will show again, we will confirm what we have showed already, how dangerous these substances are, how unnecessary they are, and how ineffective they are. Even the dosage is absolutely depending on, on accident. How you call it? It's arbitrary, because even these authorities, they don't know how much of the spike proteins are produced in the body of the vaccinated people. They don't know how long, what quality, and the quantity. So that's against the basic rule of pharmacology, that the dosage is not known and the quality.
I want to stay just a little bit more at this Article 10 of the FMH-Richtlinien Ethical Codex, because we talked about we have to inform about what we don't know, but this article also says that we also have to inform patients about potential other treatments.
Yes.
Which opens the door to early treatment for substances already registered by Swissmedic, like hydroxychloroquine and ivermectin, molecules known since decades, and every registered medical doctor has the right to prescribe as an off-label prescription. And I did do this with all the patients who were agreeing to take this medication, despite not being yet recognized as an indication, COVID not being yet recognized as an indication for these substances. But then I prepared, my lawyer prepared a written consent, and I informed this is not an official indication yet. People were happy, walked away, and then they took the treatment, and people in most cases were doing very well. So Article 10 also opens the door to early treatment, but even there have been problems here in Switzerland.
Well, it does not only open the door, it's one of the legal bases why the doctor has to talk about alternative treatments. That's an obligation of the doctor. That's also, it derives from the very provision that is the basis for the authorization itself. In Article 9A of our Medical Products Act, it says it shall be authorized only for cases where there's no already authorized alternative. So we have alternatives, as you have mentioned. There are more to it, preventive alternatives. And so it's an absolute must-do for any doctor and also for health authorities to inform people about how they can stay fit, how can they strengthen their immune system on a natural way. That's already very low level, but very important, very basic. And of course, what to do once they should be infected, once they think they are infected, because as we mentioned, that is also a big question mark, who is actually considered to be COVID-19 infected.
So what is the legal base that health authorities were literally saying, no, you have no right to use this substance like ivermectin. In Switzerland, we have a situation where we have federal states. We have a federal, how do we explain this? A confederation, which is a national state, and then we have canton, which would be smaller states within Switzerland, and they all have their own health authorities like Kantonsarzt. Huh?
Yes.
Now I know colleagues who told me that in some of the French-speaking cantons, the Kantonsarzt said you have no right to use. It's actually forbidden. Forbidden. It's the prescription of ivermectin or hydroxychloroquine is forbidden. What is the legal base of medical authorities to make such a claim, to write this to the medical professional who sees patients every day?
Well, I can argue the other way around. It is absolutely forbidden to restrict on a systematic level the principle of informed consent by pushing doctors or patients into an uninformed consent. This is one of the worst crimes you can possibly think of, and that is why it was put into this Article 7, as I mentioned already, because this is the anti-torture article. So this is an example of torture, actually, to subject people to such a kind of experimental substance without giving them alternatives, without clearly telling, look, we have here a number of alternatives. And I can only tell you that our proceedings will not have their end with our criminal complaint against Swissmedic. We do have other actors that, in this way you are mentioning, are pushing people into an an unlegal situation by telling the doctors, don't provide the patient all the information he needs. Don't allow him to make an informed consent, just inject it. We are here very close to war crimes, very close. I don't say that it is a war crime, but it's certainly something that authorities should definitely avoid, looking at all these provisions we have mentioned and looking also at the practice that our Swiss Supreme Court, the federal court, has established under the title of informed consent. We also have an interesting and very good article written by this organization of Swiss doctors, FMH, that appeared in early 2021, that explicitly explained for the doctors all the details of this informed consent, which you just mentioned. So the alternative treatments and the question whether it is really necessary, and also all the question marks that are associated with this new substances. And also, of course.
So the use of offline prescriptions like for hydroxychloroquine, ivermectin, even not yet recommended by, let's say, the Swiss Society of Infectiology, yet the doctors actually were perfectly right, perfectly legal, and even obliged actually to look into this alternative.
I haven't seen an official prohibition to prescribe ivermectin or the other product. I mean, if we had an official prohibition in the sense of an legal act, this act in itself, of course, would in itself be in conflict with all these provisions I just mentioned, but it would still be in existence,
yes,
and would then lead to potential fines. Have you seen this act?
I
haven't seen it.
I have to research that. I must say, to be correct here, that in the canton I'm working, the Kantonsarzt, the highest medical authority, send out a letter and said you can do off-label prescriptions. You can do but you absolutely need to have a written consent. You don't have a written consent, you run into troubles. Now there's something else, there's another layer into that, because I was doing that systematically with patients they got the written consent. They had to take the written consent to the pharmacy. They had to take the prescription with them, go to the pharmacy. Now the problem was that the pharmacists have been so much intimidated that they refused to give ivermectin. So there was another layer to that. The pharmacists have been intimidated, and she said, well, listen, we don't do that, it's too much trouble. We have too much administrative work with this kind of medication, we don't do it. So those patients who found a doctor to prescribe and to offer a prescription, they have another challenge to find the pharmacy who dared to give out the medication.
Okay, I see. Yeah, that's a reason, one of the reasons why it is so important that we move forward with our criminal complaint against Swissmedic. Because with this complaint, we will submit a huge set of evidence, undisputable evidence, for the fact that these substances never should have been authorized and that they should have taken off from the market a long time ago. And so all these questions with respect to doctors following their own conscience and following the true medical rules, the eternal medical rules, I must say, because they apply already for thousands of years, would be out of the fire, you know. And I tend to invest my time and all my resources at the source of the problem. And one of the sources within Switzerland, of course, the true source is without, but if we just look within the jurisdiction of Switzerland, the source is this authorization that we fight against and that we have good reason to continue this fight.
So if there is a colleague who is listening to this conversation with Phillip Kruse, and he has a document he received by medical authorities saying explicitly that the use of ivermectin is forbidden, then I would be very happy and grateful if somebody could send that to me, and then I would pass it on to you, if you agree.
Yes, pleasure, yeah.
I'd like to turn the conversation a little bit towards Geneva. It's not far away, and we have the WHO there. The World Health Organization has played a major role. The way this COVID-19 pandemic has been orchestrated, or let's say managed, there are certain changes planned. Can you talk us a bit through the role of the WHO the last 3 years and what is planned in terms of changes?
Yes, it's a big question. I try to make it as short as possible because this is the right approach, exactly your question. We have first to look back on what the WHO did and how they did it and to qualify their actions before we can turn to the future. And this is actually a principle of good quality practice, of good quality management. To first do a reassessment, to do an after-action review after you have done an investment, such a huge investment as it was done by every state, and literally as it was borne by the people. They had to suffer under the measures. So it would be very normal, actually, and the usual standard to look what have we done good and what should be done better next time. Now, looking back, and even we first need to consider what's the status quo, what's the actual legal situation when it comes to the position of WHO. And their position is actually they can call out for this pandemic under the technical term of public health emergency of international concern. Abbreviation is FAKE. And they can, this is called out actually by the Director General, who literally can call it upon certain advice, but he decides himself whether he wants to call out. But that's just an formal status. there is no direct measure connected to this announcement. There is no obligation whatsoever for any of the states to do a lockdown, to make masks mandatory, or to implement other mandates. There's no such thing. But still, looking back the past 3 years, just because WHO recommended PCR test as the gold standard, every country did it and did apply the PCR test as the sole only means and as the sole method to establish the effective epidemiological risk. And that's very strange to see, because the normal thing up to 2020 actually to establish a disease was a doctor's treatment, doctor's examination. So that's
Direct patient
doctor's contact, absolutely. And the opposite then was introduced in February, in March, stay at home.
Right.
Don't see your doctor, just do a PCR. And so by looking at the real effective behavior of the countries, we could conclude that already as of February 2020, WHO had the effective power of giving the orders top-down that were just simply then executed by the state authorities. Although there was no such written, formal authority.
Right, it was voluntarily.
It was just done. It was just done. And personal, as a lawyer, I have carried out more than 20 ordinary court procedures, and I have communicated with all branches of our Swiss state. I can tell you that the reason, or I can tell you that the significance or the quality of this PCR test has never been put into question by the government and nor by the parliament. Although I managed to get a positive judgment from the Swiss Federal Court, who said in November 2021, they said, yes, Mr. Kruse, you're right. It is notorious. It is even notorious that the PCR test result is not an evidence for disease, for transmittable disease.
So that has been admitted.
Yeah, they have admitted that. They have even written that in this judgment. It is notorious, which is quite remarkable. So they didn't just write, oh, in your specific case, we agree that the proof was not sufficient. No, it is notorious. So we thought at the time, December 2021, victory. We just show this piece of the judgment. We show it to the federal government. We show it to our members of parliament, and epidemics is over. The pandemic is over. The war is on. But they didn't take it into consideration. They didn't read it. Not one single newspaper has brought it. They totally ignored it, and they continued the state of pandemics still on the presumption of these tests resulting, of the figures resulting from this test. This is just one example, but it's probably the most important, most significant example.
So it has been recognized. The limitations of the PCR tests have been very clearly recognized, but no real implications.
Yes.
On how the system still continues working.
Yes. If you speak to people here on the street, nobody would know that the PCR is bullshit. Yeah, nobody would know. Why did I mention that? Because just to show how strong the power of the WHO is. I mean, there's actually no other explanation for this phenomenon. Why all the countries in the same time applied the PCR method only as the gold standard for justification of all these mandates.
Do they
There's
have
no
to be
other
a
explanation.
supranational organization?
I mean, there must be something other than the nation itself. When you have this, they are acting like a ballet, you know, doing the same step in the same time, the same move. So there